We'd had previous testimony that there was virtually nothing that you can get with a no warrant NSL that you couldn't get by going through FISA. Was that right?
That's wrong. We're limited to what we can get under NSLs. There are broader categories of records we certainly can get going through the FISA court under 215.
You can get more out of
Yes.
FISA than you can get with an NSL?
Yes.
Then remind me why we need, and then you can get an emergency after the fact warrant under FISA.
Yes.
So why do we need to do this without a warrant?
Because we need to react quickly to terrorist threats. We need the capability of immediately, when we get information on individuals who may want to communicate with others, we need to get that information. We need to get the information, say, on a number, 10, 15, 20 numbers. If we make an arrest someplace and we find an address book, and the numbers are in that address book of a terrorist, we have to know with whom that terrorist is communicating, and we need to get that information quickly. And we cannot take the time, in my mind, to go through that which is necessary to have the court review the paperwork in order to get that information.
Now, isn't there an after-the-fact procedure where you can go get the information and then later get around to the paperwork?
That's true, but the paperwork for the court proceeding to get a FISA, where you are seeking the right to intercept the content, the conversations of an individual, is generally a quarter of an inch thick. It requires the certification by me, the certification by the Attorney General, an affidavit by an agent, and it is to require that in order to get the information on a subscriber would be an inordinate burden and would hobble us, as I've said before, in our ability to swiftly react to the threat of terrorism.
Wait a minute. I thought you said you could already swiftly react, go get the information, and then do the paperwork when you get around to it.
But we would be, the paperwork would inundate us. I've given you some examples of what we do in terms of needing the subscriber information, the email information, and the like. And we do it countlessly, day in and day out.
The advantage of a warrant is that it's an ex parte proceeding. Only one side is represented, so you can't possibly lose the case. But the idea, the fact that you just have to explain to somebody what you're doing, kind of has a little check and balance to it that you don't have when you just go on your own, get what you want.
Well, there are, in my mind, several checks and balances. Internal checks and balances in the...
I'm sorry, but some of us look at checks and balances as one branch of government looking over another branch of government. An employee of the executive branch checking with a subordinate does not constitute, in my mind, a check and balance.
I was going to go on to say also the Department of Justice, the Inspector General's office, that under the original Patriot Act and the revisions to the Patriot Act, is looking at our processes and procedures, and ultimately as well the checks and balances from Congress, the other branch of government. In my mind, where the intrusion into privacy is somewhat limited when it comes to toll records and the like, the necessity for going through the FISA process is much reduced. In the same way in the criminal sphere, where a grand jury subpoena is issued on a relevant standard, but if there is more a more dramatic incursion into the privacy rights in terms of a Title III and the like, you go to a court.